Welcome to this session with representatives from the Office of the Ombudsperson of British Columbia. We at the Law Foundation and at Legal Aid BC are so pleased that everyone's been able to join us today and throughout this extended conference, which is running over several months instead of over several days. Thank you everybody for your participation and for making this work so that we're still able to come together in some way despite the circumstances. Today I'm really pleased that we have people from the Office of the Ombudsperson to speak with us. Their bios are in the SCED system, so I won't read them off, but we're joined today by Chalke QC, who is the Ombudsperson of British Columbia, and from his office, Zoe Macmillan, who goes by she, her pronouns, who is an Ombudsperson Investigator with their social programs team, and Rachel Warren, who is the manager of the Public Authority Consultation and Training team. I'm Josh Patterson. I use he, him pronouns, and I'm the Executive Director of the Law Foundation. A few quick housekeeping notes for the session today. If you have questions that you'd like to ask, we would certainly love that. The way to do that is to put questions in the Q&A feature, which should be at the bottom of your Zoom window if you are on a computer, and not put your questions in the chat. You're free to chat and make observations and comments in the chat stream. Folks should just be aware that any personal chats back and forth could be seen by organizers later. They're not necessarily private just to you, so I want to make sure folks are aware of that. And that's all I have to start out. We're going to have a question and answer session at the end of the panel, and I will toss it over to the Ombudsperson of British Columbia, Chalke QC.
Good afternoon. Thank you, Josh, very much for that introduction. Before we begin, I'd like to respectfully acknowledge that all three of us presenters today are going to be speaking to you from the traditional territory of the Lekwungen speaking people and from now the Songhees and Esquimalt First Nations. And we thank them for sharing the land, their land with us. Thanks to all of you for taking some time this afternoon to learn a little bit about the Ombudsperson of British Columbia, our services, and how we can help you and your clients in your incredibly important work as advocates across the province. I know that your work is incredibly important. I, for a number of years, was on the board of the Law Foundation and as well had responsibility for the regulation of legal aid. And when I was at the Ministry of the Attorney General, and had opportunity to speak to this conference when it was held in person. So good on everybody for making it work this year, this very unusual year. It's just one of the additional myriad challenges that I know that all of us and all of you are facing in 2020, and it's like there's a whole bunch of new obstacles in our paths, but somehow we figure out how to make things work. And so what I do know, though, is that the work that you do makes an incredible difference to people. It makes a difference to people who very much need your help and your services, and many of those people are people we see as well. So I think we share that that perspective on how difficult, but how challenging, but how important it is to meet those challenges this year in particular. Really, sort of reaching out to people who are vulnerable is one of our priorities. We have 5 strategic priorities, and one of them is people who need us are aware of our services and can access them. It's when the pandemic hit, we did extra work in terms of outreach focused on people who might be disproportionately impacted by the pandemic and who are having extra challenges getting access to services. We know how incredibly important it is that you are in sharing information about the services that best meet the needs of the people who come to you for help. So a few months ago, we reached out to all the advocates across the province just to outline that we continue to be available through the pandemic. I wanted to remind everybody of that, and we're fully operational through this period of time. We have staff receiving complaints and inquiries every day. We have translation services available for people whose first language isn't English. And our services, as I'm sure you know, are free, independent, and impartial. So largely, our services have continued pretty much uninterrupted and unchanged in the course of the pandemic. But the challenge of there have been many challenges for people to access government services, and so I certainly know that our services and yours are particularly important. As you go about the work with the marginalized individuals that you serve, remember that in appropriate cases, you can turn to us and know that we'll carry out our role, which is to determine whether or not people who are impacted by decisions of public bodies, provincial and local, have been treated fairly and reasonably, and we'll carry out those investigations in appropriate cases. So, little bit of background about our office. We have a weird name, Ombudsperson. People don't always understand what fairness is about. But I think to this group, you will be well familiar with principles of administrative justice, and we're really part of the fabric of access to administrative justice. We know that often when people think about justice, they think about courts, but they don't always necessarily think about something like an ombuds office. And next week, we'll be joining our colleagues from across North America to note Ombuds Day, and it's really something to raise awareness about how we contribute to the world of administrative justice. So what's our role? Is always going to talk a bit about our jurisdiction when we get there, but big picture, a couple of quotes to think about. In 1977, when the Ombudsman Act was being debated in the legislature, the Attorney General of British Columbia described us in this way. The Ombudsman, he said, will be the conscience of the state, and that we would, quote, move aside roadblocks, wade through red tape, and approach the unapproachable. And a few years later, the Supreme Court of Canada, in litigation between our office and the government of British Columbia, endorsed our office's role, citing an earlier case and saying that the Ombudsman's role was to, quote, bring the lamp of scrutiny to otherwise dark places, even over the resistance of those who would draw the blinds. And last year, the Nova Scotia Court of Appeal described the role of the Ombudsman with this endorsement. The authority of the Ombudsman to investigate and report on the actions or inactions of elected or unelected government officials serves as a potent tool for citizens with cause to doubt the claims of transparency and accountability from those whose hands control the levers of power. Exposing such untruths and failures to follow the law is a laudable objective in ensuring good government. And later, the court said, the legislative purpose of the Ombudsman is remedial. His broad statutory jurisdiction enables him to act as a watchdog over the operations of government. He has legislative authority to provide an impartial and independent review of the government by providing an independent and impartial review of provincial and municipal departments. This is achieved by applying a broad purposive interpretation to the Ombudsman's statutorily defined jurisdiction, informed by the special, important, and unique role the Ombudsman plays in our constitutional democracy. The Ombudsman's authority is a potent force which acts as part of a system of legislative checks and balances on the proper functioning of our democratic institutions. The Ombudsman's oversight reminds both government and its bureaucracy that they, like the citizens they serve, are bound by the rule of law and will be held to account for its breach. And a few months ago, just to bring us up to 2020, former Chief Justice of Canada, Beverly McLaughlin, observed, the pandemic has highlighted, quote, that our reliance on only one mode of dispensing justice is wholly and woefully inadequate. And I couldn't agree more. The real stories that we hear every day, and I know you do as well, are telling us loud and clear that a holistic approach to justice can't be ignored, particularly for the vulnerable. Those struggling with poverty and mental health issues, disability, and so many more complicated issues that life has thrown at them need accessible ways to resolve their problems. And people need one-on-one guidance. They need to be communicated in a way that they understand, and they need to be heard and understood. And we know that a costly court process is simply out of reach for many. In Legal Aid BC's recently released regular survey of low-income clients, just 42% found the justice system was effective at solving problems. So there's no question we have to help people know there are other ways to get justice. The more broadly we can think about justice and how it can be achieved in all its forms, the more the public will be effectively served. Where a different way people can achieve administrative justice, a more informal, often more timely and certainly less costly way. And while we can't help everyone, every day we help some, and whether it's helping navigate the maze of bureaucracy, fixing a problem quickly through our early resolution process, or rigorously investigating a case with all the tools available to us under our legislation. So we too can make things more fair and just for people, and by doing so identify and seek changes to public administration to make government more fair going forward. So today we're going to talk a bit about some of our work in action. Zoe Macmillan, as Josh said, is one of our investigators on our social programs team, and she'll take you through some of our investigative work. And Rachel Warren, who leads our public authority consultation and training team, will talk about some of the proactive work we've been doing, providing advice to public bodies to make their service more fair, to, as well as training to achieve the same purpose. And after that, we'll be happy to, three of us will be happy to take your questions, and Josh will be, I think, reading those out as when the time comes. So, again, a big thank you to all of you and the important work that you do every day. And with that, I'm going to turn it over to Zoe.
Great, thank you so much. As Jay said, my name is Zoe Macmillan. I'm one of the investigators at the office, and I'm really excited to have this opportunity to talk to you about the work that we do, and also to be one of many of the really incredible presenters that I see are in your training schedule. I also noticed some familiar names on the registration list, so even though I maybe can't see you, I'm really happy that you're here today. I'm also excited. It's a bit of a return performance for me. Many years ago when I was working as an advocate, I had presented at a Law Foundation training session, so happy to be back. And I'm here today still as an advocate, but wearing a slightly different hat. So that's because we are advocates for fairness. So let me just build the case here, so just bear with me for a second. But there's a lot of ways in which the work that we do is kind of similar to what you do. And a lot of the skills that we need to have to do a good job are the same skills that you would be having. So as it says, ombuds, they're just like you. And so here's all the ways. So I think one of the big things is just listening to people. So when we get a complainant coming to our office, just like when you have somebody who comes to you looking for help with a legal issue, they're looking for someone who's going to listen to them, but also feel like they're being heard. So they want to talk about, what they've experienced, the challenges and frustrations maybe they've already been through in trying to sort out a problem, and they've really come with the hope that you're going to be someone who can make things better for them. So we get a lot of those same conversations, and we want to hear people, and we also really want to understand what a person's complaint is and all the details of it, all the twists and turns of their experiences. And not only to ensure that they feel as though they're being heard, but that so we really have a good handle on what exactly their complaint is about, so we can decide whether or not there could be some role for our office. So we listen, we ask lots and lots of questions. We ask, for example, if there's been a decision made, to see a copy of that decision. If they've been having correspondence, we would like to see copies of that information too, so like emails and things like that. And again, probably similar for you in your own work as well. You want to get a really good handle about what the complaints is all about. The other thing that we have in common is a need to be really persuasive in our problem solving. So unlike the courts, the Ombudsperson's office, we don't have the power to order a public authority to take a certain course of action. We can make recommendations, but they're not binding. But that doesn't stop us from resolving hundreds of complaints every year. And we do that with our persuasiveness. And we do that by identifying there's been an unfairness, we build our case, we set out what the facts are, and we lay out all the information for the public authority. So our ability to resolve these problems that a person has, it's the same type of skill of persuasiveness that you're probably using all the time in the course of your own advocacy work. The other way in which we're similar is that we need to be knowledgeable about a lot of different program areas. And that's because there's hundreds of diverse public authorities that are under our jurisdiction. So we really need to be familiar with a whole array of different services and programs that a member of the public might be relying on and then coming to our office to make a complaint about. Not only is that so that we can do our work in investigating a complaint and understanding, what should have happened in a certain situation, but it's also, for example, to make a referral for somebody so that we're able to give them something useful when they're coming into the door if we're maybe not the right spot to resolve the issue. And I would suspect many of you are pretty familiar with referrals too, but wanting to make really good referrals. So that's my persuasive case to you about how we're just like advocates. Now, that all being said, there are some differences. So, we're advocates, but we're advocates for fairness. We don't advocate for the complainants who are coming to our office to make a complaint. And we're also not advocates for the public authority that we're investigating. And we are, one way of saying it would be that we're the ref on the field. We're making the calls. And we are independent, we are impartial, and we're neutral. So not only are we not rooting for one of the teams to win, we also can't be seen to be rooting for one of the teams to win. So when we're doing our work, it's something we're very mindful of. The other thing is that we do our work in private. So what that means is that if we're starting an investigation, we wouldn't be giving complainants, extending the sports metaphor here, which is surprising for me. I'm not really a sports person, but I guess we're not giving complainants a real-time play-by-play about everything that we're doing, all the information we're getting from the public authority and passing it right along to them. We are going to let the complainant know the outcome of our investigation, but what we're doing is we are going to be maybe distilling some of that information that we're getting from the public authority. It also means that we don't report out the outcome of every single one of our investigations. We do have public reports, and some of you hopefully are familiar with them. And in our annual report, we do publish a select number of case summaries of the work that we've done in the preceding year, but generally we're not public about the outcome of those investigations. And the last way in which we are probably kind of different is about the information that we're able to have access to in order to do our advocacy for the improvement of public services. So the Ombudsperson Act which is the act under which we conduct our work, it has really broad information collection powers, which is important because for it to be a really good investigation, we want to make sure we've got the very best information and a really complete picture about what's been going on. So although there's some limited exceptions about the type of stuff we might be able to get at, we generally have access to the kind of things that a member of the public might not generally be able to have access to, or you yourselves in the course of your work. So, you know, we can interview decision makers, we can obtain records that might otherwise not be able to be released, and we can even issue summons to produce records, or we can examine people under oath. So that's kind of a difference in our work as well. So we're the same, but we're different. So who can you complain to us about? Now, as I said, we need to know a lot about a lot of different areas. That's because there's over 1,000 public authorities that we can investigate. So it's a huge array. I think some people are maybe more familiar with the provincial ministries as a branch, but it's also all the schools, your local governments, health authorities. It's really it's overwhelming sometimes if you look at the list. And our website now has a really neat tool for the public. It's called Complaint Checker. And what that has is that it gives some specific information about those organizations we maybe more get complaints about or that we're more familiar with. And so it gives a member of the public some details about that, also talks about whether or not we could investigate, and it gives some like specific referrals for a complaint about that agency as well, so people can get some really good information. So that's on our website. It's a pretty recent addition. And as I said, it's called Complaint Checker, and check it out. So that's who we do investigate. Who do we not investigate? Anything federal, I think that's kind of an easy starting point. The police, the court decisions. On there you'll see private disputes. So what that means is, and sort of like just as a distinction, for example, if a tenant had a complaint about their landlord, we wouldn't be able to investigate that. We don't have jurisdiction to look at a complaint like that. Now, if that landlord-tenant dispute ended up at the RTB, and then a person had a complaint about how the RTB had dealt with it, we do have jurisdiction over the RTB. So even though we wouldn't be looking at that private dispute, if it gets to an oversight body, that's then where we would maybe have a role. It's the same thing, for example, if it was like a patient complaining about their doctor. If it went to the College of Physicians and Surgeons, that's when we could have some oversight role. Or if, for example, a client had a complaint about their lawyer and it went to the Law Society. So that's kind of a little word about the private disputes. So who do we hear about? About 50% of the complaints that we get are about government ministries. And at least last year, our top 3 ministries that we heard about were MSDPR, MCFD, and the Ministry of Public Safety and Solicitor General. And our top non-ministry complaint sources, we have the health authorities, ICBC, WCB, BC Hydro, and BC Housing. Now, what do we do with it then? It came into the door. You can see we have a pretty high number of cases, so just over 7,000 last year. Now, they're not all complaints. You can see a big chunk of those are actually inquiries, so people looking for some information. And then there's the little sort of pie charts on there as well, showing you a bit of a breakdown about how we handled those complaints after they got through the door. So as I said, some of those are just an inquiry situation. Some are going to be going to our early resolution, and they may get closed at intake. And and actually that's quite a lot. There's 80% are dealt with at intake, and only 20% are assigned to the investigations teams. So that's kind of broadly speaking what we did with those complaints, at least last year. So I'm just going to take a bit of a moment here to talk about what happens when a complaint actually comes through the door. I thought that would be really useful information for you all to know, either for yourselves if you're wanting to make a complaint, or if you are wanting to assist one of your clients and are thinking about reaching out to our office to make a complaint. They may have questions for you about, well, what could I expect in that process? Now, of course, we'd always be happy to answer that question directly, but just for you to know as well, what to expect. What does it look like? What's kind of the nuts and bolts of our own process? So a complaint can come through the door either by phone, through, we have an online complaint form, mail, fax. Generally, we would also have in-person services. Currently, our office is closed for in-person, and our office is located in Victoria. In other times, we would have that office open, and we would usually try to get out at least once a year to go on a tour, which sounds really exciting. Like, I don't know, you're a rock musician. I don't know, I've never been on one of these tours, so I'm assuming it's exactly like being a musician. Jay probably would disagree, but I don't know. But to get around to different communities in the province so we can be face-to-face and usually do some presentations. So we also take complaints in person. So once it comes in through the door, our intake team has a look at it. And the intake team is going to be doing a preliminary assessment. So looking to see whether or not we have jurisdiction. So remember that slide a little while back, you know, is it a complaint about a private dispute, about the police, is it about a ministry? So those types of big picture jurisdiction questions. Sometimes we would just be providing some information to a person. Maybe they're looking for some of those resolution type referrals, and we would send a person off to go through that process if they haven't done so already. So for example, if we ask the person, you know, you're making a complaint about, let's say, like BC Housing, and we would say, well, have you complained about this to BC Housing? You know, have you gone through the complaints process? And if the person says, well, no, they hadn't done that yet, then we would give them information about that process, and we would send them back to try to give the public authority an opportunity to resolve and respond to the complaint. And then, you know, welcome the person back after if they're still dissatisfied with what happened. So the referrals, the going back to try to resolve it, our intake team would be doing that. Now, a small number of those complaints might be appropriate for our early resolution process program here. These are the types of complaints where they're not really like a complex administrative fairness issue. Quite often, these are the types of complaints that have to do with things like communication or some delay, and we can try to facilitate those types of communications to get the process back on track for a person. So like, for example, if you had somebody whose kids were in care and maybe they had a complaint that they said, well, their social worker wasn't getting back to them, or that they had tried to talk to a team leader about what was going on and they just weren't getting anywhere and they're frustrated about what was happening with visits. What we might do is take that complaint to our early resolution process and see this as like a kind of a breakdown in communication type issue, which is a fairness issue. If the person's feeling like they're not being treated fairly and they're not being responded to in a way that's adequate or timely. So our early resolution team is going to work to try to connect the pieces between the person making the complaint and maybe reaching out to who that team leader is to say that, you know, they're wanting to get a call from you and making that connection. Now, just because it goes to early resolution and we're getting the parties speaking again, doesn't mean that it might not still end up at an investigation stage. So it's kind of like a way to, as I said, keep the process flowing. The one thing I want to mention as well is just a word about agent authorization forms. So at any stage in our process, so either just at intake, early resolution, or if something's moving on to the investigations process, which I'll speak to in a moment, you can act on behalf of your client in their dealing with our office. So some of you might be familiar with like a release of information type form that you would have a client fill out in the course of your advocacy. We have an agent authorization form, which basically is so that a client could designate you as their agent for the purposes of their complaint with our office. And we get that quite often when a person is working with an advocate. It can be really helpful because sometimes you can have a pretty transitory interaction with a client in your day-to-day work, and they're maybe not in a place where they're going to be able to see it through just because where they're at, but that you are somebody who could do that on their behalf. So if you can work with that person, get the details of their complaint, and if you have an agent authorization form filled out and sent into our office, then that just helps get their complaint through our door. So that's about the agent form. So on to the investigation process. So I don't want to spend too much time on this. I'm sure you're more interested in hearing a little bit about the types of cases that we work on, but just sort of as like a snapshot. So the complaint, it's gone through the intake, maybe it's gone through early resolution, maybe it's not suitable for that, and it's going to go over to the investigations. So our office has 3 investigations teams, and we do that to sort of break up the hundreds of public authorities. So they're kind of themed. As was mentioned in the introduction, I'm an investigator in the social programs team. So our team has the complaints about MSDPR, MCFD, but also, for example, like BC Housing, PGT, so school districts, kind of social programs-y things. We also have another team as our regulatory programs team. So they are getting all the complaints around the ICBC, WCB, the DIRT ministries, and adult corrections. And we have our health and local services team. So they're getting the complaints about the health authorities, local governments, regulatory bodies. So the complaint then gets to our team. It's going to be waiting assignment. Depending on where we're at with files, it could be a little bit of a wait. But we do also triage those complaints. So if it's something that's really urgent, and I think we see this probably most often with the MSDPR complaints, that complaint's going to have, we're going to look at that sooner because of the urgency. So for example, if somebody says, my check is being held, I'm not able to pay my rent, I'm worried I'm going to get evicted, I have no food, we're going to look at that complaint on a more expedited basis. The other types of complaints that we triage is if it's a complaint from a young person, we want to connect with them as soon as possible. So as I was mentioning, we have the responsibility for the MCFD complaints. So that would include kids in care and also kids who are at the youth correction centers. So we look at those on a more expedited basis. We do a preliminary assessment. So wanting to maybe do some research, we're going to reach out to the complainant, get lots of information, make sure we have a really clear understanding about what their complaint is. And we're really looking to see, is there some role for our office? So is this a matter of administrative fairness? Is this, has the person already gone through some complaints process, or have they tried that? And if not, then we might be declining to investigate. So it's that type of assessment period. And if we decide that it just doesn't seem like there's a role for us, then we would decline to investigate, but we would always communicate that decision to the person and not just close it without having that discussion. We generally send our decisions in writing as well with our reasons. because that's the fair thing to do. If we do decide that we're going to investigate, then we provide notice to the public authority. So up to this point, the public authority doesn't know that the person has contacted our office to make a complaint. So it's only once we make the decision that we need to initiate an investigation that we then would be notifying that public authority. And once we start that process, then that's when we're going to be getting the information from the public authority side. So just like how, you know, we wanted to give the complainant an opportunity to tell us all the information, we want to hear all the information from the public authority, because we want to get both sides of the story, because we are impartial, we're neutral, we want a full picture. So we are going to get the records that we feel we need. We're going to just get a better sense of what's going on. And if we have seen that, yes, there was some unfairness that happened, we went in on that for an investigation, our goal is always to try to resolve the complaint. And most of the resolutions we get, because we have our really great persuasive advocacy skills. So we lay out our case about what's happened, we identify the facts, and we're hoping that that public authority is going to recognize that, yes, there was some unfairness that happened here, and we identify some possible solutions about how that could be addressed. And then we would be closing our file because the issue was resolved. So once we would be closing the file, we're going to send a letter to the complainant with our reasons about why we're satisfied or why we think it's been resolved. And we'd also be letting the public authority know why we've made the decision to end our investigation. So I know that was a whole lot about the investigation process, but again, just so that in your mind, you could maybe see the picture about how this process flows. And some investigations are really quick. They might just be, you know, a few day turnaround time on a quick urgent income assistance issue. Some investigations are a lot more complex and they're going to take potentially a lot more time. So it can be kind of variable. So what might those outcomes be I mentioned about earlier, about how we would resolve a complaint? So the nice thing about our legislation is that it doesn't define the limitations of what an outcome could be. So it's really us identifying what would be an appropriate way to resolve something. So if a person feels like they've been treated really unfairly, maybe an apology is appropriate. If a person has, you know, there was a decision and they got a decision letter, and when we looked at it, the reasons didn't seem very adequate for the person to actually understand why they were maybe denied a benefit. And we say, well, that's problematic. You want to have better decision making and clearer reasons. Then we would suggest, why don't you send them better reasons for a decision? So that could be another outcome. And it also means that sometimes we can have a resolution on a single complaint that's going to benefit a lot of people, because you could have a improved policy or procedure or reimbursement of expenses. So I think now we can move on to look at what would be some of those examples. Okay, so what I'm going to do now is talk about 3 investigations that resulted in systemic changes for clients who are receiving services from MSD-PR. Now, although all 3 of these all involve the same public authority, each one of them represents kind of a different way about how we do our work and how our investigations can result in improvements that have to public administration that have really broad impacts. So a ombudsperson investigation can begin in several different ways. So I just walked you through the individual complaint stream. That's really the backbone of our work, is those individual complaint investigations. Now, the Ombudsperson can also initiate an investigation into any matter that's within our jurisdiction, or also the Legislative Assembly can refer a matter to our Office for Investigation. And we have had that experience. We had a referral. It was resulted in the misfire report some of you may be familiar with regarding the Ministry of Health. So we've got those 3 different types of ways that a complaint could get started. And we've got here a systemic investigation report. So that's holding pattern about wait times at the ministry. So that's one of our examples. We have a special report about an individual complaint about earnings exemptions that led to the resolution of a systemic problem. So that was an individual complaint that had a broad outcome and was released as a public report. And then our third example here, we have an individual complaint that was about adding a dependent to a file that when we investigated, the resolution not only fixed the issue for that person, but it also came with a policy change that helps other people as well. So, and before I walk through these examples, I just want to note how advocates played a really important role in at least 2 of these investigations. So the way that the working within the rules investigation came to our door was that it was an advocate working with a client who had identified this unfairness. And I'm going to turn now over to the holding pattern report, which also had advocates facilitating complaints coming to us about wait times. And also in the course of doing the investigation, we interviewed some advocates too, who are able to give us their firsthand accounts of the challenges their clients were experiencing. So looking here over at holding pattern, as some of you may be familiar with this report, it had to do with the range of complaints about long wait times, disconnected calls, call time limits, and just generally challenges that people were experiencing when they were trying to access services through the ministry's centralized telephone line. The report found that the call wait times were chronically and consistently unreasonably long. We found that the ministry didn't provide a reasonable level of service through its centralized phone line, and in part because it didn't have enough staff answering the phone. And the other issue that we found was that the ministry had tried to mitigate these long wait times by doing a couple different things. So, you know, one such example, and as some of you might be experienced, would be a client calls, the call gets answered, and then instead of actually providing the service to that person at the moment, they just create a service request for the call, and they say, somebody will get back to you in a while to talk to you about what you need. So even though you're clearing the queue because you're getting through a lot of phone calls, what's just happening is that you're pushing it down the road. So those clients are still getting a delay in their services, which is problematic. We also found out that some of the staff who would be answering the phone were reassigned from in-person services. And we wanted to assess then whether that was creating some delays in people getting in-person services. But we learned in the course of our investigation that the ministry actually didn't have any standards for delivering its in-person services. And also that the ministry wasn't monitoring wait times for in-person in this area. And the report found that that was unreasonable. So what did we recommend? I'm sorry, my computer just made a noise there, even though Rachel told me how to prevent that from happening. So, so to address our findings, we made 9 recommendations in 3 different areas. So they're aimed at addressing those staffing levels at the ministry that I mentioned, recommendations to bring some public transparency about the phone wait times. Some of you might know now that the ministry has monthly reports about their daily wait times, and there's also an annual audit of those times, so that increasing that transparency. And also recommendations to address the issues that we had identified with the in-person wait times, and also the mitigation strategies that I was mentioning before that we found were unreasonable. So the ministry accepted 6 of those recommendations. They offered alternative commitments to 2, which had to do with the staffing as well as the service level for how long they would be answering the phones. So the service level that they proposed was to have that 80% of the time calls are answered within 10 minutes. So that was their alternative for the wait times. And they also said they didn't have the technical capacity to meet one of the recommendations, which was the monitoring for in-person wait times. Now, those were the recommendations when the report came out. And since then, we have released a monitoring report, so to see how they're doing in implementing things. So we monitor the recommendations that we make, and we'll issue periodic updates on our reports and the recommendations. And we start our monitoring once the report is released publicly. So as part of our monitoring, we're going to get some information from the public authority. So they have to tell us what steps they've actually taken to implement the recommendations. And we want like specific information that we can actually verify. Just like a general, yes, we would like to do it, is not going to be sufficient. And then what we do is once we have this information, we can decide whether or not we think the recommendation has been fully implemented. So in our February 2020 monitoring, we reported that 4 out of 9 had been implemented, that even though the ministry had decided the standard that they were going to meet for timeliness of phone services, you know, that 80% of calls are answered within 10 minutes, in our monitoring, we reported out that they're actually only meeting this 1/3 of the time. Also, that they still don't have a timeline for the timeliness of in-person services. And even though there had been a budget lift to increase staffing levels, that this was not sufficient. So the monitoring is to be continued. So that's that one report. Now we're going to shift gears and move over to working within the rules. So, as I mentioned before, this was a public report, and it was all the result of a single complaint that was made to our office and a single complaint that was made with the help of an advocate. And the circumstances were, this person has the Persons with Persistent Multiple Barriers status, so PPMB. The person was able to work casually, but they kind of had like a fluctuating income. Sometimes they made so much that they were actually over the threshold for eligibility. And what was happening in that situation was that the ministry was applying a policy they had at the time where they suspended the earnings exemption that the person would be able to get for 1 month, because they said that they had been disentitled to the earnings exemption because they had been over their rates because of their income. But this policy was actually inconsistent with what the law said about earnings exemptions. Now, what was troubling in this case was that this same conclusion had also been reached by the ministry, but it was at reconsideration. So what would happen was this client would have this experience, the ministry would say you're not eligible, they would have to submit reconsideration, and they would be successful at reconsideration. And even though they were successful at reconsideration, when it happened all over again, and the ministry would continue to apply this policy. So after we initiated an investigation into the individual complaint, and we got information from the ministry about the policy and what was going on, our investigation actually broadened to consider whether the ministry just generally, with the application of this policy, was being inconsistent with the legislative authority. So it wasn't just something that was happening to this one particular client, but it was affecting everybody more broadly. And what we found was that, yeah, it was a problem that the ministry's application of this 1 month waiting period policy was contrary to law. We also found that the ministry was acting improperly and in breach of its duty to its clients by continuing to publish a policy and to apply the policy when it actually knew its interpretation of the law was wrong, because we saw that at reconsideration, and that the ministry was acting unjustly and oppressively by requiring that a client have to go to reconsideration because of this policy in order to get the decision reversed. So that's what we found. And we made some recommendations. So first of all, to make eligibility decisions that were consistent with the law, and that they needed to amend the policy so that it complied with the law. So that was sort of the quick ones, but also the recommendations were that the ministry would reimburse all recipients whose benefits had been miscalculated because of the application of this policy. Because in investigating this one individual complaint, seeing that this was a broader issue, we saw that lots of other people had been impacted by this over the years. And the final recommendation was that they needed to develop some guidelines so that when there were these types of legal errors, which we saw had been occurring in this person's case, where it was being bumped up to reconsideration, reconsideration said, yeah, this is not right, but then nothing happened with that, is that the ministry would have to develop something so that their reconsideration branch would be communicating within the ministry to identify these sort of systemic issues happening. So those were the recommendations, and let's see where we're at for the recommendation implementation. So this was our monitoring that was released in January 2019, which really feels like forever ago now, but 3 out of 4 have been implemented. So policy's been changed, correct eligibility decisions being made. The guidelines are now in place, so they have that process to communicate issues between reconsideration to their executive. And then, so just talking about the reimbursements though, and I note here on the slide that lots of people are still waiting for their money. So when we first released the report, the ministry said that 2,600 people had been impacted by this. And some of the people were still on assistance, so they were able to be issued a reimbursement quite easily. But then the ministry said that the people who were no longer clients, they were having more of a challenge reaching out to them. So the ministry had sent letters to these individuals' last known addresses, asking them to contact the ministry so they could arrange for payment. And as of December 2018, 516 former clients had contacted the ministry, but there's still a lot of people out there who are owed money. So we're still monitoring this, and just a little reminder, if in the course of your advocacy work, you think maybe you're talking to somebody who could have been impacted by this and they're no longer receiving assistance, it might be worthwhile directing them to the ministry to follow up if they're owed some money. So I'm now going to talk about our final case example. So this is another one of another MSDPR complaint, another individual complaint. And in this case, the complaint was resolved for the individual, but also has ended up having some broader impacts. And this has to do, again, about a policy. And sort of generally the circumstances here was, it was a person, they were a grandparent and they were providing care for their grandchild. And this is because MCFD had gotten involved, and the person didn't have legal custody of their grandchild, but they did have a letter from the parent explaining the arrangement. And the person in this case, they submitted that letter to MSDPR saying, you know, I'm looking after my grandchild now. Here's the letter from the parent. I want to add that grandchild to my file as a dependent. And what happened is the ministry said, sorry, our policy says, unless you're the biological or adoptive parent or you are the legal guardian, we can't do that. So you would have to come to us with proof of legal custody before we're going to add the child to the file. And as I'm sure many of you know, having that child added to the file was going to make a big difference to them as far as the financial supports that they would be able to receive to assist in that care. So the person came to our office because they just didn't know what to do. They were getting this response. They didn't have a custody agreement, but they were experiencing a lot of challenges in trying to resolve this. So when we looked at the case and we looked at the legislation, instead of just looking at the policy, the legislation we saw, it didn't actually limit eligibility in the way that the policy seemed to contemplate. So by telling this person that they needed to have proof of legal custody, the ministry is actually applying an eligibility criteria that was more restrictive than what the legislation said in terms of who could be a parent. So when we identified this problem with the ministry in our investigation, the ministry agreed that the policy could be changed or should be changed so that it was in line with what the law actually said. And they also shared with us some of their proposed revisions to the policy. So we could give some input to make sure that the policy and the process that staff are to follow when they're reviewing a request to add a dependent, it's meeting our expectations of what we think should be a fair process. So now, instead of requiring legal proof, staff are supposed to instead assess in a more qualitative way what's the nature of the relationship between the child and the person who is the parent to decide whether or not they should appropriately be added to the file. So in this case, the complainant, they got a underpayment reimbursement of just over $2,000 by having that grandchild added to the file. But it also means that now there is a different policy and procedure for anybody who has found themselves in a similar situation. So those are 3 examples of 3 investigations involving MSDPR that had some broader impacts. But just sort of quickly talking about some other positive outcomes on some individual files. These are ones that we've reported out publicly in our annual reports. And there's lots of great case summaries in those reports if you're interested. So for example, improved language accessibility for people seeking legal aid in a language other than English. So we had a complaint about LSS, and there was a re-recording the messages on its immigration line to include a number of language prompts, including Spanish. So that was one outcome on a file. When we got a complaint from a CLBC client who was living in a group home, and the issue had to do with the communications that they had been provided when there was a decision to move them to a different home. The outcome of that was that they got a written apology for their experience and how the person had been communicated with. So that's kind of an individual or an example of an individual complaint and a nice outcome where then the person felt that they had been heard. Another example here was a complaint from an inmate, and it had to do with a visit by an HIV awareness outreach group. And by having this group visit with the inmate, they were inadvertently releasing the person's status. And the person said that this was causing them conflict in the center. So we investigated it. The detention center agreed that they would implement changes so that the inmates would meet with outreach workers in a place that was had some more privacy so that this wouldn't occur again. And another just example here, BC housing complaint. and it had to do with the rental calculation guide and the different types of income that were being used for that calculation, and to extend an income exemption to include all child support payments, so including all federal and provincial child benefits when it's assessing a tenant's income. So that was like an individual complaint. It actually had a more broad outcome as well. So that's just sort of a quick run through of a couple of individual cases as well. So I think that is the end of my talking time. So I guess I'll be handing it over to Rachel now.
Okay, thanks, Zoe. Great. Thanks, everybody. I'm just going to progress the slides here. Yeah, so I'm just going to talk to you a little bit about our team. I'm really happy to be here, and thank you again for including us in your schedule today. Just want to share a little bit about our team's approach and mandate, which is a little bit different than the important work that's done on the investigation side of our office that Zoe talked about. So I'll spend the last part of our session, the next 10 or 15 minutes or so, talking about the work of our consultation and training team. So our team came together as a pilot program in the summer of 2017, and we were known then as the Prevention Initiatives Program. And we received funding from the legislature for a 3-year pilot to create a team that was dedicated to doing more of sort of proactive and preventative work with public bodies, with the goal of promoting good public administration outside of our office's primary investigation mandate. And we were lucky. I mean, one of the reasons Jay decided to ask the legislature for this funding is that we had heard feedback in our strategic planning consultations in 2016 that public authority staff really wanted our office to engage with them more proactively and not just to contact them when in response to a complaint. They also wanted to know what we looked for when we were investigating complaints. And they wanted education on the administrative fairness standards that we hold for government service providers. They also told us it would be helpful if we shared more information with them about the kinds of complaints and any trends or issues that we were seeing to help them with their own continuous improvement processes. And also they wanted us to contribute to their programs and policies more proactively to build that fairness in to the design from the start to hopefully prevent problems and to help them with their own internal complaints processes to be able to respond better when things did go wrong. And one of the primary reasons that Jay wanted to create this pilot program is and take this more proactive approach is that we know it's often better and significantly less expensive to prevent problems before they happen than to try and repair the damage after it's been done. And that's the old saying, an ounce of prevention is worth a pound of cure. And what we know is that in our experience that many of these problems in government administration are preventable with some work ahead of time. So the program ran from the fall of 2017 to March of this year, and we underwent a comprehensive independent evaluation, which included surveys with hundreds of public sector employees who had engaged with the program. And the results of the evaluation indicated that there was value in us continuing to do this more proactive work. So our team was made a permanent feature of our office through an ongoing funding commitment just this year by the legislature, and we were just renamed the Public Authority Consultation and Training Team. So that's a bit of a background. I want to talk to you a little bit about just briefly some of the key initiatives of the pilot program. So one of the things we did was to develop some educational resources for public bodies, public sector staff on administrative fairness. So we developed some webinars, we deliver in-person workshops, we've trained over 3,000 public sector employees across the province. We tailor our training sessions to, and train anywhere from frontline to executive leaders of our top volume authorities. So like MSDPR and BC Hydro, BC Housing, all the top volume authorities. And we've recently taken that in-person training and are now delivering it virtually. So we've got several sessions lined up in the month ahead. Second key initiative was to offer voluntary consultation with public bodies outside of our investigation context. So really to provide advice and feedback to help them ensure that their procedures are fair. And this voluntary consultation offers just a more informal approach as compared to our formal investigation process, but really with the same effect of providing that input from our administrative fairness perspective into improving public programs and services. So I'll tell you a little bit about some of those consultations in just a moment. And then third, the final initiative was to publish a number of best practice guides and resources. And when we first came together, we set out the goal of making sure that these resources were easily accessible, written in plain language, and just presented in a way that busy public servants could actually use. So this meant getting away from some of our longer, more detailed reports. So we've produced a number of quick tips on topics relating to administrative fairness, procedural fairness, effective communication. A number of those they're all on our website. And we've also created a couple of best practice guides that are also on our website that cover topics related to administrative fairness and decision making. So I'll tell you a little bit about a few examples of the kinds of work we've done on that voluntary consultation I was just mentioning. So I'll first tell you about some work we did with the Mental Health Review Board. So the class report featured on the slide there that was released in November 2017, which I'm sure most of you are familiar with, exposed a number of cracks in the board's process. And shortly after its release, we were approached by the new chair of the Mental Health Review Board, who wanted our assistance in improving the board's procedures and addressing some of those recommendations in the report. And at the time, the board, the chair was working on a complete revision of their processes. And I know that CLAS and a number of other advocacy groups were consulted on the new rules. But essentially, we provided feedback on their draft rules of practice and procedure and on 8 practice directives that related to things like guidelines for disclosure and procedures that facilities must follow to ensure a fair process. And so we wanted to make sure that procedural fairness was built into these processes, make sure that people were being provided with access to a fair hearing, and that there were no barriers for patients' access to a panel hearing. So making sure that facilities were facilitating that access to review, making sure patients had access to a telephone, could contact the mental health law program, providing transportation and alternate clothing, those sorts of things. And then also ensuring that mandatory reviews done every 12 months for patients on extended leave under the Mental Health Act were actually done in a way that was meaningful and didn't rely solely on the patient's past diagnosis without providing a description of how the patient continues to meet the criteria for detention, for involuntary detention, and why they can't be considered a voluntary patient. So we gave a number of feedback on all of those rules and practice directives through that voluntary consultation with our team. We'll give another example. We also worked with Court Services Branch on their new complaints policy. So they had approached us for our assistance in developing a complaints process in January 2018. They didn't actually have a process in place at that time. So there was no really meaningful avenue for people to complain about their services. And court services includes programs run by sheriff services, and our office receives complaints about sheriff services from people who are highly vulnerable due to restrictions on their liberties. So there's a higher duty of fairness owed to them, and they should have an adequate opportunity to complain and appeal decisions that impact them. So we consulted with court services on the development of a complaints policy that was focused on principles of accountability, consistency, and timeliness, with an emphasis placed on informally resolving complaints at the point they're received to achieve an expeditious resolution to the concerns, but also with procedures built in where concerns or more serious concerns could be raised through formal channels and investigated properly. So their complaints process was released in the spring of 2018, and it's now accessible and posted on their website. And our office noticed a significant decrease in the number of complaints once they implemented their policies. So the year after their policy was publicized, we saw a 46% drop in complaints about court services and a 68% drop in complaints about sheriff services. Now, building the capacity in the organization itself to resolve complaints and respond to them adequately may have caused that. We can't attribute a decrease in complaints necessarily to that, but certainly having a good complaints process in place where, concerns can be addressed and heard and resolved at the point of contact is good for everybody. And then another example I'll just tell you quickly about is with the Forensic Psychiatric Hospital with the Provincial Health Services Authority. So we were approached last January by PHSA for some assistance in improving their complaints process for patients and families who receive services from the Forensic Psychiatric Hospital. And historically, the hospital had a very informal complaints process in place. It was called the Patient Concerns Committee. And they heard minor complaints, such as concerns with the quality of food being provided or general complaints about the facility. But there wasn't much information provided to patients and families about how to receive more, to raise more serious complaints. And we know again with this population, there's a higher duty of fairness owed, given that essentially every aspect of their lives is controlled by administrative decisions made by healthcare staff. And so they needed a safe and effective avenue to raise concerns. So we worked collaboratively with staff from the hospital and the PHSA Patient Care Quality Office on the development of a new process. And wanted to make sure that there were adequate procedures outlined to investigate complaints adequately and thoroughly, and that procedural fairness was, again, built into that process. So things like access to an impartial decision maker, providing the patient an opportunity to be heard in the process, making sure that privacy and confidentiality was respected throughout the process, and making sure that patients were provided with clear and meaningful reasons at the conclusion of a complaints review. So those are just three examples that I wanted to share. It shows the value of building fairness into these processes outside of the context of a complaint, where we have a public authority that's willing to work with us in a voluntary manner to improve their services. And I'm really thrilled with the work of the team and feel that we can have a really broad impact through proactively engaging with public bodies and be seen as a resource to them. Our office can be helpful and a resource to help improve public administration while still maintaining our independence and impartiality as an oversight body as we continue to receive and investigate complaints about those public bodies that we've engaged with in our team. So I'll just finish off with the current context on a consultation we're working on now since the onset of COVID. So what we found was that the benefit of establishing those positive relationships before the pandemic meant that government has been willing to seek our assistance with the changes, the rapid changes they've had to make during COVID-19. And this has given us an opportunity to build fairness into these new programs from the start and act nimbly and quickly as things were changing so fast. So we've worked with a number of organizations, but I'll just give one example here relating to the Ministry of Public Safety and Solicitor General's role in enforcing the public health officer's orders. So Ministerial Order 93 there, issued under the Emergency Program Act, appointed a number of provincial employees from a number of different ministries, from gaming and cannabis and liquor inspectors and a number of different provincial special constables to new roles in enforcing Dr. Henry's orders relating to large gatherings and events, and also serving as a border screening function for returning travelers to BC who were required to self-isolate under the Federal Quarantine Act. And this group of provincial employees was also responsible for advising local bylaw officers around the province who had received similar new powers under another Emergency Program Act order. And a separate unit of the ministry had been set up to provide training, advice, and support to the field, to these bylaw officers. And we know from our office's experience investigating complaints about bylaw enforcement that a lot of concerns are frequently raised in that context. So We worked with the ministry on the training and advice that could be provided by the central unit to ensure administrative fairness in carrying out the enforcement role established by these two ministerial orders. The focus has been on seeking voluntary compliance, taking progressive enforcement action, and so we wanted to make sure that these enforcement decisions and procedures that were being developed were legal and fair and communicated clearly to those that were impacted, along with information about how to appeal these decisions. And as you likely know, the ministry has since issued another EPA order that authorizes police and these provincial employees to issue violation tickets for other COVID-related infractions. So we continue to engage with the ministry in a proactive way to help promote fairness in the exercise of these new powers. So I hope that gives you a sense of the kind of work our team does. It was a very quick, brief overview of that, but I wanted to share a little bit about our work and how we play a part in our office's overall mandate of ensuring fairness. And I'm going to turn things back over to Jay now to finish off the session and answer any questions you may have.
Thank you, Rachel. I'll briefly go over, skip over the last comments I was going to make, which were really about what we're doing in the context of the pandemic, but I also really very much want to get to your questions. So just suffice it to say that part of what we're doing is we are monitoring, as are other ombuds in Canada and indeed around the world, the exercise of emergency powers by governments during the pandemic emergency. And we released a report in June that concluded that 2 of the emergency orders issued by the Solicitor General under the Emergency Program Act were unlawful in that they exceeded his statutory authority. And we made a number of recommendations related to that, some of which are already been implemented. So just it's good for everyone to know that that's part of what we're doing during the pandemic, not just our regular work, but also trying to make sure that government here in British Columbia, just like ombudsmen are doing all over the world, as I say, respecting the law in the exercise of their emergency powers. I think with that, I'd like to turn it back to Josh and entertain some of your questions.
Thanks very much, Jay, and thanks, Rachel and Zoe and Jay, for your really informative presentations. And it was nice to hear that some of the big pieces of work that you've been able to do over the last few years have had connection to advocates across the province and other Law Foundation funded groups who make complaints to you from time to time and are using the system that you have set up for people that they're serving. So it's really gratifying, I'm sure, for everyone to hear that. So question, this is a pretty short one. Does the Ombudsperson's Office have jurisdiction over First Nations bans established under the Indian Act and their policies and their decisions?
Well, thanks, Josh. The answer is that to the degree that a First Nation is exercising authority under its governance under the Indian Act, the Federal Indian Act, the answer is no, we do not, nor do we have jurisdiction when they're exercising treaty self-government rights. We've been doing a fair bit of work with First Nations and treaty governments to share to the degree that they're interested in receiving our advice regarding administrative fairness. So we're there for them. But when they're exercising that jurisdiction, it's outside our jurisdiction. Our jurisdiction is completely statutory and comes from the schedule at the back of the Ombudsperson Act. And I see in the chat there was also a question about investigating private universities and colleges. And the answer to that is the same. Because our jurisdiction is statutory, we have jurisdiction in the post-secondary world over any institution designated under the University Act or any institution designated under the College and Institute Act, but not with respect to private career training. But we do have jurisdiction over the Ministry of Advanced Education, and a number of years ago we were concerned about the regulation of the private career training institution world by the Ministry of Advanced Education. So we investigated the scheme that the ministry had for regulating and protecting the public interest and the interest of students who attended private career training institutions. And so you can see on our website, there's a report called In the Public Interest. We released an update to that report in September of 2018, I believe, in which we basically went back to our earlier report and tried to determine how the ministry had been doing. And some things have been done, but there were still a number of recommendations that are yet to be implemented.
Thanks very much, Jay. Another question is, can you talk about whether there are any instances where the public authority who's being investigated by the Ombudsperson's office essentially hires counsel, whether internal counsel from the government or external law firms?
So that can happen. Typically, it happens in the context of contests about our jurisdiction. But after 40 years, those are relatively few and far between. There are some types of organizations that are created, new organizations that are created, and so there may be jurisdictional questions as to whether they're under our jurisdiction, but it doesn't happen often. More commonly, lawyers on behalf of public authorities get involved with respect to contests about our access to particular forms of records or information. But again, that's pretty rare. Our authority under Section 15 of the Ombudsperson Act is quite universal, not unlimited, but quite broad. And so those questions happen only rarely.
And quickly, what about municipal governments? We've talked about a few non-specifically provincial governments. Can you comment on municipal governments?
Sure, I can comment, and then Zoe or Rachel, if they want to chip in. We have jurisdiction over pretty much all manner of local governments, whether that be municipalities, regional districts, local improvement districts, waterworks districts. So pretty much any type of local government that's created by provincial law, we have jurisdiction over that as well. They comprise about 15% of our total work. In terms of the number of complaints and inquiries we get. It's definitely an area that's increasing. So we've tried in an area like that, and Rachel can speak to this, I'm sure, to try to support local governments by adopting a bit of a best practice approach. We've issued best practices about some of the reports about some of the areas where we get frequent complaints, things like open meetings. People complain to us that sometimes council or a committee of council will go into closed in-camera session improperly. And so we've issued a best practice guide about when that's permissible and when it's not. And obviously the default is open government at the local government level, as well as with respect to bylaw enforcement. And I know that's an area that we get a lot of complaints as well. And that work actually comes quite up to the present that Rachel was referring to with respect to the COVID guidelines that we issued or worked with Public Safety and Solicitor General on, because really it was the same kind of administrative action. Rachel, I don't know if you want to add anything.
Yeah, I guess I would just say that we presented at the UBCM conference last year as well, and saw a real interest in a complaint handling kind of information session that we presented on, because local governments do see people at their level that can escalate quite quickly in their complaints. So we gave a presentation on effective complaint handling for local governments that was really well received. So we try and do things like that as well through our team, doing more of that kind of education work, proactive work. That's about it.
Thanks, Rachel and Jay. There was a question in the chat that you kind of covered off up at the top about how to access your services and the eligibility criteria. So I wonder if you can maybe just hit that note again, and maybe this is on your website too, but whether there are any questions as to whether you have to have exhausted a bunch of other channels before coming to you. It might be worthwhile folks hearing about that.
So the question of exhausting other channels is something that we frequently encounter at our intake stage. Some people call us very quickly after the first bump in the road that they hit with a public authority, and there may be a well-established review process that's open to them. So in those circumstances, we expect people to use the available remedies that they do have open to them and try that. But as I think Zoe was talking about before, we always say if you're still unhappy once you've gone through that step, to please come back to us. It's discretionary in us. So there are circumstances where we won't insist on that. And I think Zoe mentioned some of them. For example, when a young person reaches out to us, very frequently we'll take that complaint, even if they may have an available remedy that's open to them. So we have discretion, but our general practice is to ensure that people or to promote people taking advantage of the opportunities that a public authority has. It's good for them, frankly, if it's good for the member of the public, because they maintain control over their own case at that stage. It's good for the public authority. They get a chance to quickly reestablish a good working relationship with a member of the public. And it's good for us because we can reserve our scarce resources to investigating cases where people haven't been able to resolve their problems.
Thanks for reiterating that. I think that's really useful to our advocates out in the field. We've got one more question from the room, which is there a role for you to assist or compel BC Housing to hold the housing providers that they fund accountable?
Sure. Often we get into questions about what what we can do with respect to government and public institutions when they're funding private operators. Very much it ends up on a case-by-case kind of analysis to determine whether or not that public institution, BC Housing, is absolutely a public body within our jurisdiction. And so we hold them to the same standard that we would hold a government ministry for example. So we'd look at their process around their funding decisions with respect to a private or not-for-profit entity that's outside our jurisdiction, but BC Housing is inside, and so we're holding them to those same standards of fairness.
This may be a quick one. I think you might have answered this already, but probably useful to repeat. The general timelines for your office to deal with a complaint from the public. I don't think this is asking about deadline to file a complaint. I think it's about how long it takes you to deal with a complaint, but maybe you can address both.
I'll say a few things, and then Zoe can talk a bit about the kinds of things that you might find in an investigation. But basically, we're doing investigation work, and so it's a bit of a how long is a piece of string kind of answer. Some people call us, especially people who are whose whole issue gets resolved by our intake and early resolution team. They'll call us, and that matter can get dealt with that day. We might open an early resolution file, and they make some calls and are able to resolve the matter that afternoon. And if it's a single parent who has a complaint about a denial of a crisis grant for groceries, that's the kind of urgency that I would expect our staff to apply to a complaint like that. So that would be the kind of, that would be the ideal time kind of, turnaround. On the other hand, we end up in a big complicated investigation. We're having trouble with records or multiple witnesses. There's controverted issues of fact. And we're having difficulty. We lose track of complainants. That can happen as well. All of those things. So investigations can go on much longer. About 70% of our investigations are resolved in the first 90 days, and so that's kind of where we're at. But we have investigations that go on much longer than that, and ones that are resolved more quickly.
Sounds like there's a quick follow-up on the floor to the housing question as to whether your involvement can extend through to the practices and policies of funded housing providers, not just BC Housing. So if they're contracting with someone.
So sometimes we get into those questions, and it's the question of whether the public authority, in this case BC Housing, has appropriately set standards for those private operators to follow. And so the government's failure, or a public authority's failure to establish those standards, can in itself render an unfairness. So while the individual operator would be outside our jurisdiction, it could be that BC Housing's failure to take an appropriate, a particular step may indeed be unfair.
Thanks so much, Jay. That's time. We are out of time, folks, for this afternoon. I want to thank Rachel and Zoe and Jay for joining us today and sharing so much information. We really, really appreciate it. Thanks to Kate at PovNet for moderating this and for others helping out both at the Law Foundation and at Legal Aid BC. Before you go, I'll compliment the Ombudsperson on their new logo. It's nicely cleaned up, looks great. We are two of the only sort of provincial agencies that use the dogwood, I think, as part of our logo, us and the old BC Ferries. So it's almost like we're a team.
There you go.
Anyways, it looks lovely. Congratulations on all the great work that you've done this year. We didn't talk about lots of other work you're doing in mental health. Folks should go on their website and find some really interesting findings about the Mental Health Act and how it's administered in BC. Thanks very much. Congratulations as well on this high school report, which students' rights and education around their information, another huge piece of work. So thank you very much for everything you do for folks in British Columbia. And thanks everyone for joining us today. That's a wrap.
Thank you.
Thanks everybody.